Section 44-53-2240 of the bill talks about DHEC denying, revoking, or suspending the registry identification card of a qualifying patient or a designated caregiver if they do not comply with the provisions of this bill. If they violate any of the restrictions that I'm going through here, the penalty is revocation, and you can't participate in the program any longer. Section 44-53-2250 talks about, let me see, if law enforcement has probable cause to believe that cannabis products are possessed at a specific address in violation of South Carolina law, then the officer may verify whether the address is associated with a qualifying patient, designated caregiver, or medical cannabis establishment through the Department's verification system. Okay, so that is meant to give law enforcement access to this DHEC registry database, so that if law enforcement believes an individual may be in possession of cannabis for whatever reason, if they have probable cause to think so, that they have the ability to go into DHEC's registry to see whether or not that individual is a member of the program, because of course that may inform the law enforcement as to whether or not they want to go ahead and confront the individual or ask the individual about why he's possessing cannabis. It gives SLED the ability to access that database for that particular information. Whether somebody that they suspect of having cannabis, they can check DHEC's records to see whether or not that person is a registered cardholder. And that's section, I'm sorry, I don't know if I said it, section 44-53-2250. Section 44-53-2260 is what I kind of refer to in my own head as the Chamber of Commerce section. One of the things that I did over the years in working on this bill, again, as I say, I worked with various stakeholders, worked with law enforcement, worked with the faith community, worked with DHEC, worked with, the medical community. I also worked with the business community and the Chamber of Commerce and said, okay, look at this bill and provide me with your feedback on it. And this is what they wanted in there. This subparagraph I'm about to read to you, subparagraph C, in that section 44-53-2260. Nothing in this article requires an employer to make any accommodation for the use of medical cannabis products on the property or premises of any place of employment, to allow the ingestion of cannabis products in any workplace, or to allow any employee to work while under the influence of medical cannabis products. This article in no way limits an employer's ability to discipline or terminate an employee for being under the influence of medical cannabis products in the workplace or for working while under the influence of medical cannabis products. So, in other words, the right to access cannabis to address your medical condition, if you have a card, if the physician authorizes it, if you have a debilitating medical condition, that does not trump the right of an employer to dictate what that workplace environment is going to be. Okay, that's what this particular section of the bill stands for that proposition. I think Senator Senator Rice, Senator from Pickens asked this question further in that section 44-53-2260. Says, subsection F says, nothing in this article requires a motor carrier or private carrier as defined in section 5823-1110 to make any accommodation for the use of cannabis products by any employee whose duties affect the safety or operation of motor vehicles in transportation on public roads. That was added in there at the request of the Trucking Association. They wanted to make certain that they, again, similar to other employers controlling their workplace, the truckers wanted to have that degree of control in regard to their employees. Section 44-53-2265, again, reiterates, this article does not affect the ability of a private employer to enforce a drug-free workplace policy or zero-tolerance drug testing policy prohibiting any applicant or employee from having a detectable amount of marijuana metabolites in the applicant or employee system. Again, this is all part of my conversation with the Chamber of Commerce. Section 44-53-2270 says that a person who is employed by or has contracted with the state of South Carolina is not subject to arrest by law enforcement if they have a medical cannabis card. So in other words, contracting with the state or being employed by the state is not a prohibition against you using medical cannabis. So I guess you could look at it in a way as being a carve-out to that general rule in regard to the workplace. I have said in regard to the state that if you're an employee of the state or someone who contracts with the state, that you cannot be precluded from having a medical cannabis card and having cannabis as medicine if a physician authorizes it. Again, this is something that we can discuss if the body doesn't think that's appropriate. But again, I'm going through the bill and telling you what it says at this point in time. Section 44-53-2280 talks about a school or a landlord. No school or landlord may refuse to enroll, lease to, or otherwise penalize a person solely for the person's status as a cardholder, unless failing to do so would violate federal law or regulations or cause the school or landlord to use a monetary or licensing-related benefit under federal law. Again, understanding that in some cases you're going to have federal funds or federal involvement. And again, this is still a Schedule I drug under federal law, so not wanting to put the landlord or the school in a position of jeopardizing those federal funds. Section 44-53-2290 states that this is in regard to a standard of care. And again, this goes to the conversation I had with the senator from Charleston, Senator Senn, last week. A physician may not be sued for medical malpractice as a result of certifying a qualified patient's medical use of a cannabis product in accordance with this article. However, the immunities provided by this section shall not be construed to prevent a physician from being penalized or sued for violating the standard of care or for any violations of this article, including certifying a person for medical cannabis products who does not have a debilitating medical condition. So, in other words, a physician is subject to the same malpractice standards, the same standard of care, that there's no safe harbor created, but by the same token, the mere fact of authorizing medical cannabis for use by a patient is not prima facie evidence of negligence. But again, that particular prohibition against a prima facie presumption that somebody is acting negligently by authorizing medical cannabis, that is then qualified by saying the physician still has to exercise due care in connection with authorizing the use of cannabis or otherwise providing care to a patient who is accessing medical cannabis. Section 44-53-2300 provides various information in regard to financial institutions that accept the deposit of proceeds from medical cannabis establishments. I talked a little bit in the past about the guidance that's been given in that regard by the FinCEN division of the Department of Treasury, that there's a laundry list of things that credit unions and banks need to do in order to avoid penalties or fines. Again, a large part of this whole banking piece of it is going to be driven by those guidelines given by the federal government. And this just gives me another opportunity to sort of reiterate what I said when I first began this discussion way back last Wednesday. The federal government has accepted this as happening. It has green-lighted this. Every year in the budget, it passes a rider that says the Department of Justice can't use any funds to interfere with states that have medical cannabis laws. The IRS issues formal recommendations and guidance to medical cannabis establishments on how to file their taxes. The Department of Treasury, again, has those particular guidelines given to financial institutions. You've got the Department of Treasury also has certain guidelines in regard, Department of Justice, excuse me, in regard to the Hart-Scott-Rodino Antitrust Act. How can medical cannabis establishments comply with federal antitrust law? So at various levels of federal government, you've got the federal government, either authorizing or giving a green light to states in the budget, or you've got agencies, the IRS, the Department of Justice, all issuing regulations and guidance to facilitate those who are operating in state-authorized medical cannabis programs. Section 44-532310 talks about a person is not subject to arrest by being in the vicinity of a qualifying patient engaged in the medicinal use of cannabis products. Section 44-532320 states that the lawful use of medical cannabis products pursuant to this article should not be used as a relevant factor of evidence in proceedings regarding parental rights, child welfare, guardianship, decision-making, or probate matters. However, it says that this section should not be construed to allow a person to engage in conduct that would be negligent to undertake while impaired by cannabis. So, in other words, on its face, an individual's use of medical cannabis that is legal is not evidence of whether or not that individual is fit to be a custodial parent. However, by the same token, that cannot be construed to allow the person to engage in any conduct that would be negligent. So it's similar to what we talked about earlier in regard to malpractice. The mere fact of a physician authorizing the use of medical cannabis is not indicia of malpractice. However, that physician is still subject to the same standard of care. Same thing here. A person's qualification to take medical cannabis in a custody context is not an immediate disqualification for being the proper parent to have custody. However, neither is it a safe harbor, and that person still cannot engage in conduct that would be negligent to undertake. So that's that section. Section 44-532030 talks about for the purpose of medical care, including organ and tissue transplants, a qualifying patient's use of cannabis products, according to this article, is considered the equivalent of the authorized use of any other medication used at the discretion of a physician, okay, and does not violate the use of an illicit substance law. Section 44-532340 again sets forth, this now sets forth individuals that will serve on a commission, okay? And this commission will subsequently be charged with, over time, looking at how the science of cannabis and medical conditions evolves over time, and subject to petitions and evidentiary requirements and a majority vote, can authorize further qualifying conditions, in other words, further empowering a doctor in those circumstances where he or she believes that medical cannabis can be efficacious. It sets forth who the members of that commission are, the department DHEC director, the director of LLR, the president of the South Carolina Board of Medical Examiners, the chief of SLED, a sheriff designated by the Sheriff's Association, the commissioner of the Department of Agriculture, a patient representative appointed by the governor, an industry representative appointed by the governor, an individual selected by the South Carolina Advocates for Epilepsy, a certified public accountant or an attorney, a representative of the African American community, and I believe when the senator from Spartanburg offers up his pharmacy amendment, we're going to include on this commission representation by the pharmacy sector, which I think would be appropriate given what's anticipated to be the pharmacist's involvement in the dispensing process. Section 44-53-2350 sets forth where DHEC will promulgate regulations in order to take applications for individuals who want to be licensed as a grower, a processor, a dispenser, a transporter, or an independent lab testing cannabis products. And it sets forth the various criteria and factors that DHEC will consider when establishing how those licenses or applications will be processed. This would be the section of the bill, 44-53-2350, that senators may want to draw an amendment to if they wanted to establish a preference for individuals who resided in South Carolina. If you wanted to give a weighting or a preference or a bias toward individuals who live here as opposed to individuals who don't live here, this would be the section that you would direct your attention to. That particular section also talks about and I've already gone over this earlier in regard to logo, advertising, and signage, requirements that, certain slang or marijuana leaves or things of that nature not be used in regard to the packaging or structures, prohibition against neon-colored signage, logos, packaging. Again, the thought here was that appearance matters, and we're treating this like medicine. We want it to be viewed by patients and by the public as medicine, and that having these associated marketing things that maybe some of us have seen in other states isn't something that's conducive to that sort of environment. And so that's why that language was added, because perception matters, image matters, the way the public views this matters. And so one of the things we're emphasizing to the public is this is a strictly regulated authorization for patients to use medical cannabis. It's medicine. And so we think if that's what it is, then the way it physically appears or manifests itself out there in the marketplace needs to conform with what our intent is. And that's what that section refers to. It also sets forth various standards for the independent testing laboratories. These are the laboratories that come in and inspect all cannabis products for purity, safety for human consumption, also for labeling in terms of, what the ratio of THC to CBD is in each one of these products. Every product that is purchased by a qualifying patient from a pharmacist or a dispensary is going to be properly labeled so you know exactly what you're getting. That's another thing that we've heard about some other states is that things weren't properly labeled or people didn't really know what they were consuming. They took an edible and it affected them in ways they didn't anticipate. There's information here trying to be put on the packaging to avoid that particular situation. Talked about you can't use any images designed to appeal to minors. I talked about that earlier. Okay, section this is still in section 44-53-2350. This subparagraph D talks about vaping. And restrictions on vaping. And it's important enough that I'm going to go ahead and read it in its entirety, or I can direct your attention to it. It's subparagraph D. It says, after consulting with public health experts, medical professionals, and analysts who conduct health and safety research on vaporizers, reviewing federal regulations governing electronic nicotine delivery systems, and reviewing some other states' regulations on medical cannabis vaporization, DHAC shall, or the department shall, promulgate regulations to foster the health and safety of patients using medical cannabis vaporization products. The regulations include mandating that all models of vaporization devices sold by dispensaries must be subject to laboratory testing, including stress tests and shelf life tests, requiring laboratory testing of medical cannabis cartridges that are allowed to be used with vaporization devices, including testing of aerosol-sized products, banning all additives, cutting agents, and flavorings that are known to be harmful, creating a list of any non-cannabis ingredients that are permitted to be included in a medical cannabis cartridges which have been identified as safe for inhalation, and specifying the proportion of those ingredients that are allowed in each cartridge, issuing standards for heavy metals included in the hardware, and developing warning labels that must be included on vaporization devices, including detailing any known risks. I mean, this is the, if you'll recall, a couple of years ago, there were vaping incidences, and for a while that was a topic of, how can we go ahead and establish some safety protocols in regard to vaping. That's the section of the bill that relates to that. And again, I'll give you the reference. It is section 2350, subparagraph large D, and then there are various subparagraphs 1 through 6 under that. That all relates to vaping. So if you're someone who has concerns over vaping, that would be the section of the bill that addresses that. Section 44-53-2360 goes into more detail in regard to DHAC establishing standards for and licensure of 5 independent testing laboratories to test cannabis products that are sold in the state. And then it talks about what the testing laboratory must pick up and test for, and it's the following. The concentration of THC and CBD, whether or not the testing material is organic or non-organic, moisture content, allergens, potency, any foreign matters, including heavy metals, microbiological screening results, residual solvent testing results, the presence and identification of fungi, including mold, the presence or concentration of fertilizer and other nutrients. And again, we didn't reinvent the wheel here, and neither did DHEC. We looked to other states and borrowed language from other states that had the highest possible standards in regard to testing the cannabis products for safety by the consuming public. And so this was the work product that grew out of those efforts. Section 44-53-2070 talks about the department shall require the use of a single real-time seed-to-sale tracking system used by all medical cannabis establishments. So this is what you often hear about, how technology today is such that you know in real time exactly where something is from the time it's a seed and it's planted to the time that it is dispensed to a patient who's been qualified to receive it. You're going to know exactly where that product is at all times due to the seed-to-sale tracking program. That's important because obviously we don't want diversion. We want to reassure the public there's not going to be diversion. This is a way to accomplish that objective, to require that seed-to-sale tracking system be used by all medical cannabis establishments. And by all, that means any medical cannabis establishment that comes into possession of cannabis, whether you are a grower, a processor, a dispenser, an independent lab that's testing it, or you're a transporter, you're all subject to this seed-to-sale tracking requirements. And the rest of the section talks in more detail in regard to that seed-to-sale and how that works in real time. Again, if you're interested in that aspect, it's, again, Section 44-53-2370. Section 44-53-2380, again, talks about if you're a cultivation center, if you've been licensed by DHEC to be a cultivation center or a grower, and if you conform and comply with all the requirements of this bill, that it is not going to be, it is not unlawful then for you to possess, plant, propagate, cultivate, grow, harvest, produce, process, manufacture, compound, convert, prepare, pack, repack, transport, or store cannabis. So in other words, if you are a duly authorized medical cannabis establishment and you've been authorized either to grow, to process, dispense, it is not unlawful for you then to have possession of the cannabis for that purpose. Section 44-53-2390 talks about the number of licenses that can be issued to medical cannabis establishments. Only 15 cultivation centers, so 15 centers that could grow the cannabis, 30 processing facilities, 30 facilities that could be licensed to process the cannabis into medicinal or oil consumable form, 4 transporter licenses, individuals that transport the cannabis from the growing facility to the processing facility to the dispensing facility, and 1 dispensary license for every 20 pharmacies. Now, again, this is going to be subject to the amendment that the Senator from Spartanburg has been working on, and 5 independent testing laboratories. Wanted to keep the universe of, or the number of qualified medical cannabis establishments relatively small to begin with, so that DHEC and SLED and other state officials could control the situation and monitor the situation adequately. A lot of states have unlimited number of licenses. I mean, it's just the Wild West. If you want to if you want to grow, if you want to dispense, if you want to process, you submit your application, you get a license. That's not the way we went here. We went with a tight universe, a specific defined number of medical cannabis establishments because, again, this is something new. It's a cautious first step. We didn't want to subject DHEC to something overwhelming, which again goes back to the point made by the solicitors in their letter, was that they were concerned that DHEC was going to be saddled with something that they weren't up to handling. I guess my response back would be there are revenue sources in the bill that would give them the resources for administering the program, and that the applicants and the medical cannabis actors themselves are constrained in number, again, to facilitate that oversight by DHEC as we're first starting this program. So I offer that as an additional response to the point made by the solicitors in their letter. That same section 44-53-2390 states that one of the things that it states that is that any proposed medical cannabis establishment shall not be within 1,000 feet of a public or private school. So there is a distance requirement there for those who were concerned throughout the process of proximity of medical cannabis establishments to schools. Looking further at section 44-53-2390, subparagraph I, this goes to the point made by the solicitors that an individual who's got a felony drug-related offense could be a medical cannabis establishment operator if that drug-related offense had been completed, including any term of probation or supervised release at least 5 years prior to the application being made. The point made by the solicitors is there is a lifetime ban in regard to such felonies in other sections of the code. Those of you who agree with the solicitor, that's the particular section of the bill that they have that particular concern in regard to. Section 44-53-2400 talks about the due diligence that is done every time an applicant submits an application to become a medical cannabis establishment. There is a SLED background check, an FBI background check, various other restrictions, including the one I referenced in regard to a previous felony-related drug offense, and various other things, other compliances that need to be made there by the applicant. 44-53-2410 establishes that DHEC is responsible for performing inspections of medical cannabis establishments and investigating suspected violations of the article. So the police power, so to speak, in regard to monitoring participants in the program, these licensees, falls upon DHEC. It gives it to DHEC. Section 44-53-2420 again reiterates that a medical cannabis establishment must not be located within 1,000 feet of a school. 44-53-2430 talks about, this talks about no local government may prohibit medical cannabis establishments either expressly or through the enactment of ordinances or regulations that make their operation impractical in the jurisdiction. So this is the section that those of you who are concerned with home rule aspects of this might want to direct your attention to. What this section says is a local government can zone where it wants a medical cannabis establishment to go. That falls within their land use police powers. But it says that it cannot use that power to completely deny a medical cannabis establishment from locating anywhere within the municipal limits. I believe that that's appropriate because we're talking about getting access to medicine to people. Those individuals who are concerned with home rule aspects and wanting local governments to have more control over that, that's the section you'd want to look to, 44-53-2430. The 44-53-2440 talks about various security measures that medical cannabis establishments have to have. They have to develop those security regulations after consulting with and receiving input from SLED. This is in regard to the security of the facilities themselves and the security of the harvesting, the processing, and the packaging at a secure facility. And again, SLED has the right to monitor and have input in regard to that process. It further says in subparagraph C of that particular section, again, that section's 44-53-2440, says as follows: all medical establishments are subject to random inspection by the department and SLED in accordance with regulations promulgated by the department, which shall be developed by the department after consulting with or receiving input from SLED. So in other words, SLED has at all times the right to randomly inspect these medical cannabis establishments. Again, that goes to the security aspect of this and wanting to ensure there's not diversion and ensuring that holders of licenses to have medical cannabis establishments are conforming with the law. Section 44-53-2450 requires that a cultivation center and processing facility conduct routine testing of cannabis and cannabis products at an independent testing facility in accordance with department regulations. That again, that talks about the interaction between these independent labs and the product being produced by growers and processors, the obligation of those establishments to work with those independent labs in order to allow those labs to certify it's safe for human consumption, no adulterants, and that there's the proper ratios of THC and CBD that are listed in the packaging. Section 44-53-2460 talks about what cultivation centers do with cannabis scrap and other parts of cannabis that's not being used in the production of medicine. It talks about how they're disposed of. It provides the things that they have to do in that regard. Section 44-53-2470 was my initial attempt to try to bring the expertise and experience of pharmacists and other medical professionals like nurse practitioners and physician's assistants into the dispensing area. I mean, we wanted that expertise there at that patient level. Again, this will be superseded by an amendment that I know that the Senator from Spartanburg is going to offer in regard to putting pharmacists or state licensed pharmacists in charge of the dispensing process. Section 44-53-2470, subsection C, also reiterates that all items sold at a dispensary must be properly labeled and contained in child-resistant packaging. That goes to the point the solicitors made that they wanted it in child-resistant packaging. It also talks about how the percentage of THC and CBD has to be listed on each of the products. Again, other restrictions in regard to, child-resistant packaging, conspicuous statement on all products that say for medical use only, keep out of reach of children, not for resale. I mean, just warnings in that regard. Section 44-53-2480 talks about at the dispensary level or at the pharmacy level, pharmacist level, if the amendment is adopted, there must be a flyer that is issued that contains certain baseline information about cannabis to further inform the patient as to what the effects of cannabis on them might be. Now, of course, that patient would already be getting information from the physician, would also be getting information from the pharmacist. But in addition to that, this section requires that there be a flyer that has information provided on it as well. Section 44-53-2490 talks about the penalties that can accrue to medical cannabis establishments if they violate any of these provisions. There can be revocation of licensures, monetary penalties, and other fines established by DHEC for violation of these requirements. Section 44-53-2500 talks about DHEC seeking, says it may develop and seek federal approval for and carry out research program relating to medicinal use of cannabis. Again, this speaks to an important part of this process. There is still a lot of research to be done on cannabis. There are still a lot of things that we don't know about their medical properties. And this is stating that it is the desire of the General Assembly that DHEC avail itself of any federal research programs that might be available to kind of flesh that out. And here we're primarily talking about USC School of Medicine or Medical University of South Carolina, who are already doing research in regard to cannabis, but this encourages them to continue to participate in those programs. Section 44-53-2510 requires DHEC to provide a report to the General Assembly by the second Tuesday of each year addressing the effectiveness of the medical cannabis program. So I think that's important because we need to know as a General Assembly on a regular basis, on an annual basis, from DHEC, the agency charged with administering this program, just how the program is working, to kind of keep us informed in regard to, is it operating as we expected? Are the outcomes as we anticipated? Are there things that could be better? Are there unintended consequences? So this is a recognition that this is a new program, and it's especially important that DHEC provide us on an annual basis, feedback in regard to how what we have enacted in law has worked in practice, and that's section 44-53-2510. Finally, I know you're happy to hear that. Let's see, finally, we got some boilerplate language in regard to severability clauses. We added another, if you'll recall, another section in the committee amendment that states as follows. That's in that last section. It states that again, one of the things stated in the committee amendment in section 44-53-2070, nothing in this article may be construed to require a health care insurance provider, health care plan, property or casualty insurer, or medical assistance program to be liable for or reimburse a claim for the medical use of cannabis. Again, this was at the request of the insurance industry. And then we added a new section, I believe it would be the very last section, maybe section 9, that, sections 1 through 8 shall be repealed by operation of law if a federal court, pursuant to a filing by the United States of America or one of its authorized executive agencies, issues a final order declaring that those sections have been preempted by the Federal Comprehensive Drug Abuse Prevention and Control Act of 1970, more commonly referred to as the Controlled Substances Act. And again, I went through at the very beginning last Wednesday the reasons why. In this case, the CSA on its face states that it does not preempt the field, that it does contemplate state action in the field of controlled substances. I also reviewed the case law in regard to implied preemption, whether that's obstacle prevention or impossibility prevention. And according to that case law, that would not apply in regard to this bill. So